Welcome once again to Lehto's Law. Here's Steve Lehto.
As an attorney, I'm very sensitive to the notion that people think there are too many lawsuits out there. All these crazy lawsuits people file. And I'm going to do a video right now about one of these crazy lawsuits. And I'll explain at the end the theory underlying the lawsuit. I'm not crazy about this lawsuit. I don't think it's a great one. If somebody came to me and said, do you want to handle this case? I'd be like, no. But like I said, there's an underlying theory that makes sense in some situations. So this is from AZ Family out of Phoenix. Austin Walker wrote it and Jason sent it. Thanks a lot. Driver seriously injured in DUI crash is now being sued by a passenger in the suspect's car. Imagine getting hit head-on by a suspected drunk driver and being left with life-altering injuries, only to find out that a passenger in the car with the drunk driver at the wheel is suing you for hundreds of thousands of dollars. This is not hypothetical. It's reality for a Valley family. Crash happened last month near State Route 238 west of Maricopa. We were behind my daughter by about a minute on the road. Their daughter had been driving home from a friend's house when the wife saw what she described as a horrific scene up ahead. I said, please don't let that be a Hyundai. Please don't let that be a Hyundai. The husband said, it's a Hyundai. Their daughter had been hit head-on by another driver. She's crying, saying, help me, help me. She had blood pouring out of her mouth. An ambulance rushed her to the hospital, along with the people from the other vehicle, which is the one that hit her head-on. The daughter went into respiratory failure, was placed on a ventilator, and months later, their daughter is still reeling from that tragic day. They had to do all kinds of surgery. She had complex fracture of her right femur. She's got metal rods in her back. And according to the Maricopa police, the driver of the other car faces several charges, including aggravated DUI. Okay, so what we're talking about here is there's the car with the alleged drunk driver at the wheel. Their daughter was in the car that got hit. And they were behind, and they came upon the accident shortly after it happened. So the mother says, we've worked so hard to try and come to peace while she suffers from what this driver did to our daughter. But last month, something else happened. We got a letter from their attorney sent to our insurance company. A passenger in the car driven by the drunk driver was now making a claim against them, asking for more than $500,000. The passenger's attorney argues that even though the daughter didn't cause the crash, she still owed a duty of due care because she could have swerved to avoid the collision. So the mom says it's a cash grab. The attorney they spoke to, the TV station, said this type of lawsuit isn't uncommon. Arizona is a comparative fault state. That means in any accident, the responsibility among all involved must add up to 100%. So it might be that the drunk driver is responsible for a big chunk of it, but somebody could theoretically, a jury, assign liability and fault and say, well, yeah, but the driver that got hit might have been able to avoid this. So the family says the law doesn't make a lot of sense to them. And of course, they say, they're suing the victim, which is what they're doing. And the reason that I believe that the parents are talking about this is I suspect that the parents are actually the ones who took out the insurance on the daughter's car. But I could be wrong. It doesn't clearly state that. But the family's navigating what comes next and understand that the family's insurance company will pick up the defense on this and handle that. But it's still a tough experience to go through a lawsuit, even if an insurance company is along for the ride. So the family says that they will fight the case in court. Meanwhile, the driver of the other vehicle is scheduled to be arraigned in October, but the family believes the real issue lies in Arizona's liability laws. They said they've reached out to local and state lawmakers, but have not heard back yet. And so what you're talking about here is the concept of last clear chance. 3 words, last clear chance. And it's an old concept. And in theory, I can give you some examples where it might make sense. So let's suppose that you're walking across the street one day. It's a bright sunny day. You're just having a good day. And somebody calls out to you and says, "Hey, you, look out. There's a runaway truck." And you stop in the middle of the street and you turn and look, and there's a runaway truck coming right at you. And the person who yelled to you goes, "Get out of the way. You're going to get hit by a truck." And you yell back and go, "It's not my fault. I'm legally allowed to be in the crosswalk. I don't have to move. I'm going to just stand here." And they go, "Yes, but you're going to get mowed down by a truck. You could get killed." And you go, "But it's not my fault. I'm just going to get hit by this truck." And you get hit by the truck. So the truck driver goes, "Why didn't you get out of the way?" "I don't have to get out of the way. I'm in the crosswalk." Now, I'm giving you an idiotic example, but you do understand that I would have the obligation, if I could, to get out of the way. And the concept of the last clear chance actually goes even further back into just the general notion, the general idea that if you are in a situation where harm is about to happen, whether to you or somebody else, and you have the ability to mitigate the harm, to stop the harm, or to make the harm less, generally speaking, you've got an obligation to do so. And if it's harm to you, and you don't take steps to mitigate or to avoid the harm if you could, a court can say, you got harmed this much, but you could have mitigated your damages, but you didn't. Therefore, we're going to do something about that. Some states will say you get nothing, zero, but other states say no, it'll just get apportioned. So it's possible that if the accident is mostly somebody else's fault, but partly your fault, you can still collect. Some states say if you're responsible a certain amount or more, you just lose. You can't get anything. But apparently Arizona doesn't say that. Arizona just says if you're partly responsible, you can be sued, and the person suing you will simply have an offset for how much of it was their fault. But the strange part here, and this is one of the reasons that this case will get a little further than other cases, is that it's the passenger. And the passenger can argue and say, it's certainly not my fault. It's either the driver's fault or the other person's fault, but it ain't my fault. However, astute observers are going to notice and go, wait a second, but the passenger got in the car with a drunk driver. Or were they drinking while driving? Literally. You have to ask that question. And by the way, I've seen one of these cases filed in court in Michigan. Now, I don't know how it resolved because the case settled, and it's unclear how it settled, and I don't know the answer to that question. But I saw an argument in court one day, a few years ago, where, and the story was in the news, a drunk driver driving the wrong direction on one of the freeways in Detroit where the freeway is set down, so there's tall walls to the side of you and a divider, meaning that you can't swerve off the road. There's a narrow shoulder on each side, and that's it. Drunk driver driving the wrong direction went up an entrance ramp. And as they were going up it, another couple was coming down it, head-on collision, and it killed the people in the car coming down the proper direction. And the drunk driver, as they strangely so often do, walked away from the crash without serious injuries. Some injuries, but not, they survived. They sued the people who died. And I saw the argument in court where the insurance company, on behalf of the deceased, was asking the judge to throw out the case. And this is ridiculous. You killed my clients. Now you want them to pay your damages for the injuries you caused, drunk driving the wrong direction on the freeway? And the judge actually said, unfortunately, this is a question of fact. And I've talked before how questions of fact get decided by the fact finder. And if you have a jury, it's going to be the jury. And the plaintiffs had asked for a jury trial. And the judge said, I can't throw this out. If I was a fact finder, I would, but they've asked for a jury. So you've got to ask a jury, which means that this is going to go to trial. Now, I can't imagine a terribly sympathetic story where you get in front of a jury and say, my client was drunk driving the wrong direction, exiting the lodge on an entrance ramp, and plowed into this older couple and killed them both. But we think they're at fault because they didn't swerve at the last second. They had the last clear chance. Especially considering it's an entrance ramp, you can't swerve very far. Those entrance ramps aren't terribly wide. There is not enough room, I don't believe, for cars to go like this very well because it's not designed to do that. Now, if a car breaks down up there, hopefully they roll down and get it on the shoulder down here before they block the ramp. But I'm talking about the lodge for the people in Detroit or southeastern Michigan. And it's one of those, it's a freeway that's lower than ground level where the city is. It's down there, and there's a lot of cities that have got those. So I've seen this type of case. It's not that common, and yeah, it takes a certain amount of gall to file it. But here it's the passenger saying, hey, I'm just the passenger, and there's this horrific accident, and I think that they could have avoided some of it. And a jury will have to decide that. But I'm sure the insurance company for the victim will be picking up the defense and handling it, and hopefully it's not too traumatic for everyone to go through, because as you can imagine, generally speaking, you sue the other driver, and the driver turns it over to their insurance company, and it just turns out, I believe, that the insurance company was being paid by the parents. And the parents, of course, are witnesses of the accident. If this case goes to trial, they'll testify. They'll probably have to give deposition testimony because they're witnesses. And, of course, the injured daughter is going to get dragged through this litigation. So there you go. Jason sent it. Thanks a lot from AZ Family and Austin Walker. Driver seriously injured in DUI crash, now being sued by the passenger in the suspect's car. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If quitters never win and winners never quit, what fool came up with quit while you're ahead?